Can everybody hear me okay? I honestly think the microphones might be a bit superfluous, but I think you need the microphones, don't you? Yes. This is a pre-inquiry procedure meeting into a compulsory purchase order being promoted by SP Transmission plc to acquire certain rights over land at Chestnut Avenue near Bishopton. I am Frances McCleary, the reporter appointed by Scottish Ministers to hold a public inquiry and report to them. So some housekeeping matters first. There will be no fire alarm practice today, so if the alarm should go off, I suppose it'll be a real one, so we should go outside. Could everyone put their phones and their any pinging notifications on their machinery on silent for me? And I think that's all. I used to say that no smoking was allowed, but that seems less and less necessary these days. But no smoking or vaping in the room, please. Now, before we get into the meeting proper, can I ask, has everybody got a copy of the agenda that was distributed? Everybody got a copy, or have at least seen it? Did you get it all right?
I think we did, yeah.
You did, right, okay. I don't actually have any spears with me, but as we're maybe departing slightly from the agenda, I hear, well, maybe not worrying about that. Unless you have any spears yourself with you?
I have one copy, but I could share it with... No, it's fine.
Right. Okay. Okay, so now my plan for this morning, because I've been advised there's been a change of circumstances on the objector's part, is to use the agenda only as a rough structure for the meeting. And not all of my original plans can be usefully discussed. Not all of my original topics can be usefully discussed, but there are some things about what happens next that I still need to go over. So can I start with item 2 on the agenda, and that is with the appearances of who's here today. Let's start with the promoters.
Good morning, ma'am. It's Magdalena McLean, partner at Shepherd and Wedderburn, appearing today on behalf of SP Transmission plc, and I'm accompanied by Miss Zoe Rocks, the in-house solicitor for SP Energy Networks, Mr Stephen McChristie, who's the land officer for the project, Miss Lynn Tennant, who's the project manager, and Mr Kenny McCahill, who's the construction manager for the project.
Thank you, Miss McLean. Now, Ms Hartley, would you like to introduce the objectors? Would you?
Yeah, so I'm an objector as the owner of plot number 2, Lynn Hartley. Got May Hartley, objector, owner of plot number 1, and Linda and Frank McGrath, owner of plot number 3, and the objector as well.
Thank you very much. That's helpful just to bring these together. I think I met everybody yesterday. Is that perhaps Mrs McGrath? Right, good. I'm introducing an emergency agenda item, 2A, because I understand that after our enjoyable and interesting site inspection yesterday, there may have been some developments. Could everybody tell me what's happened?
So I understand that there has been a meeting held after our site visit, and it was a productive meeting in which a number of matters have been discussed. And an agreement in principle has been reached between SP Transmission plc and the other parties to the inquiry. And although the agreement has not yet been documented, an agreement in principle is now in place. So, subject to your opinion, ma'am, we would seek assist for 6 weeks to allow for the agreement to be documented, with an update to be provided within 3 weeks to allow you confidence that matters are progressing.
Right. Well, we'll come back round to that last point, if I may. And is it the case, Ms Hartley, and I'm using your bit as a spokesman, no, so is it the case that if this is satisfactory, result to your satisfaction, you may be going to withdraw your objections to the order? Is that?
Yes, so we're looking to pause proceedings until the offer is formalised, with anticipation that the offer will be met in full, and then we would fully withdraw our objections.
Right, okay. I don't need to know the details, just that that's what you're hoping might ultimately transpire. Yes. Right, okay. But as I think I mentioned in my emails, this is an administrative procedure with a certain amount of momentum, and just because agreement is reached at some point, it doesn't mean that this follows. In fact, it usually proceeds. It will require to proceed. So I think what I should perhaps do to explain my perspective on this, having heard that there's these possibilities moving forward, what I would have been doing today would have been planning a public inquiry. So I would have been doing, what I would have been doing is taking from the representations that you've given me, I would have thought them through, decided on a number of heads of topics that would have required to have been explored, and then we would have worked through what would be the best way of exploring those. Because the whole exercise here is an investigatory one on my part. I have to come up with a report for ministers, and indeed I still have to come up with a report for ministers, notwithstanding these developments. So there's some things I think we could discuss today, and there's some things I think it would be pointless to discuss today. I mean, I think the merits, if you like, have changed. They've not completely changed, but much of them has changed. That part of the proceedings that would have potentially been adversarial is about to change, or hopefully will change once your situation. So there's no point in actually going into that in any detail, because it would potentially be abortive work. The next question is, what would the promoters really prefer me to do? And I hear you when you suggest that we maybe assist it, but on the other hand, I would imagine that your clients might want to have this matter before ministers without too much delay. Is that fair to say?
So the suggestion of assist was intended to allow for the agreements to be in place and to allow the ministers to have confidence that objections had in fact been withdrawn and that the adversarial part of the process has almost been resolved. Yeah. Yes. But however, the order requires to proceed due to the owner unknown land. So the hope was that following the assist, the oral procedure would no longer be required, and any additional information that you may require would be provided in written form to allow for a report to be provided to the ministers and for the CPO to be considered in that form.
Right. Well, I was thinking along very similar lines. The bit that I'm slightly keener to do than you seem to be yourselves is I would quite like to get on with it, that part of it which is non-adversarial, and I'd like to proceed to review the documentation.
I don't think there is any reluctance to proceed with the non-adversarial side of things. It was we were working on the assumption that you may prefer to have confidence whether the objections have been resolved. But if you're comfortable proceeding with the non-adversarial part of the procedure, then the SPC would welcome that.
Well, I think it's a bit of a judgment call on my part. Obviously, it would be faintly ridiculous to go too far into the order before there's a degree of confidence that the adversarial aspect is going to resolve. That being said, it seems to me, given my own work programme, I could perhaps usefully review some aspects of the order and therefore be in a position to move to a report without, cut out a bit of delay. And I thought you might find that.
That would be very much welcomed. Yes.
Well, I think as a matter of principle, if ministers refer a CPO order to us, we usually try to progress them as speedily as we can, and we are usually disinclined to assist cases if that's avoidable. But it was worth a wee discussion. Just to sort of make it clear what we're about here, the Acquisition of Land Authorisation Procedure, Scotland Act 1947, first schedule, which deals with public inquiries, provides that if all objections made are withdrawn, The ministers, on being satisfied that the proper notices have been published and served, may, if they think fit, confirm the order with or without modifications. So that means every time a CPO is allocated to a reporter, and the reporter must always report on it, even if the objections are withdrawn, because the ministers still have to be comfortable that the decision they take over the order is justified. I mean, compulsory purchase orders are serious matters. Quite a lot of what I was going to say, I need not say. Okay. So, jumping forward in the agenda, quite a few items. The substantive items that I was going to discuss were items 4, 5 and 6. That was the sort of headings. These are the basis for the discussion as to topics I might need to investigate. But as I've said at the outset, there's really no point in doing that just now. But I do have some comments about some matters here and later, which you might want to take on board. What it seemed to me is that, even remembering always that it falls to the promoters to convince ministers that the order should be confirmed, and that the onus, if you like, of proof is with the promoters. There are one or two things that it seemed to me I might well need beyond what you have said in your statement of reasons and alluded to in your core documents. So I think I'm expecting to be asking you for more information at some point. I think if we are going to have, if the objection is going to be withdrawn, I would certainly be asking you if you were comfortable that we go to a written submissions procedure. That's, I think, a matter for yourselves. Ministers have asked for an inquiry. The usual practice is if all parties who are affected agree, then there need not be a formal public inquiry. So I would sort of anticipate that we could go to a written submissions approach. So, leaving all those substantive questions in 4, 5 and 6 to one side just now, and moving on to the actual arrangements for the public inquiry, I had distributed a notional programme, which was intended to dovetail with my own availability over the next few weeks. I have to say, I think you asked me for 6 weeks, Ms McLean, didn't you ask me for 6 weeks?
It was intended to allow time for the agreements to be put in place, and we could undertake to provide an update within 3 weeks to allow you to understand how things are moving forward. Yeah.
I was wondering whether I should perhaps leave the inquiry procedure in place. The first deadline for yourself, and indeed for yourselves if you are still dissatisfied on my notional schedule, was Tuesday the 22nd of August. That was when I was going to ask for statements of case.
There are, I guess, two comments on that. Firstly, the hope would be that the other parties don't need to incur the expense of producing statements of case and potentially getting somebody instructed, and the inconvenience and the time spent to produce these. And secondly, from a personal perspective, I'm hoping to be moving house that weekend, so any change to that deadline to make it slightly later would be very much appreciated.
Yeah. I'm moving house in September, I hope. Right, okay. So it looks to me as if this programme is going to fall apart in the face of circumstances then, and wondered whether it might be possible to preserve it, but I don't think it is realistic to preserve it. Okay, so we'll ditch the draft programme then just now. I think what I would ask you to do is, however, to give me your first update on the 22nd of August. Could you do that? Now, I'm asking Ms McLean, but because I don't want to have to worry you with giving me an update, but it would be good if it was a joint update.
Mm-hmm.
That's just a question of it being run past you before it's submitted, so that I know that it's both parties. And I don't need a blow by blow account, and I definitely don't need to know about compensation offers or accommodation works. These are not matters for me or for ministers. But if you just give me an update as to how you've got on, and I'll review it at that point and decide what steps need to be taken. And I probably won't take any steps in terms of reviewing the paperwork until around then. So we'll make the 22nd of August a sort of review point where I can monitor progress rather than assisting it. Okay, and I won't make any decisions about what I would be asking you for. But I think if I give you a flag, having seen the site yesterday, it seemed to me that I would want the observations, at least offer the opportunity to Renfrewshire Council as Planning and Roads Authority for three matters. First of all, the implications of the use of the private road. Secondly, their function as planning authority as regards the core path network. And finally, as planning authority as regards the tree preservation order. So what I would do is contact them and ask for their observations and whether or not they would wish to become involved. Now, there's two options. I could leave that to the 22nd of August, or alternatively, to save a bit of time, I could initiate that contact to Renfrewshire Council now. Any views?
But just on the Planning Authority and Roads Authority's involvement, the Council was consulted as part of the Section 37 and deemed planning application, and has provided a response in respect of that process. And the Section 37 and deemed planning permission have now been granted by the Ministers on the 22nd of June, and a number of conditions have been imposed which address matters, amongst others, to do with the core path and traffic management and environmental management plan for the construction period to manage things such as impact on trees and impact on species and bats and birds. So separate conditions have been imposed to manage these processes, and the construction couldn't commence until the plans have been provided to the local authority and approved by the local authority.
Right. Well, that rather suggests that my inclination was at least a good question. And I don't want to. I think I would want to review these materials. There was a good example of the materials I would want to see. I think I would want to review those before deciding further. The other thing about contacting a local authority these days is it's sometimes comes up against resource issues. Right. Well, it doesn't. What you're hoping is, after I've seen the materials to which you've referred, I might consider that further contact with the council was unnecessary.
Yes, ma'am. So at this stage, we don't have a draft traffic management plan and all the plans which are required in terms of conditions, but they would be provided to the local authority prior to commencement of construction, and there would be no commencement unless approval can be granted.
So suspensive conditions. Right. Well, it looks like my second constructive suggestion about saving time may not be particularly helpful either. So I think we'll leave that then to the 22nd of August. But if I can put you on the alert that these are the topics on which I would wish my report to be able to advise ministers of the full position. Particularly these three topics, but it does sound a little bit as if the package that you're referring to might well have other matters that I could have raised questions on that I'll be able to just provide ministers with an indication as to how they've been dealt with.
I don't anticipate these would be available within the timeframe for the report to be finalised, as construction project wouldn't be. So the documents aren't available yet.
So there are contractual implications as to exactly how these things are played out. Well, that being said, from my point of view, I'm pretty clear in my own mind that I would wish to, if I was to present my report in advance of these matters, I would certainly wish to update ministers as to the exact position. I would need to be able to allow them to familiarise themselves with how these matters are intended to be managed. So it's, I could either wait until they're all finished, or I could give them an update as to the progress report, whatever.
There is a number of drafts which formed part of the environmental impact assessment report. So, for example, the schedule of mitigation, which envisages the measures that would form part of traffic management plan and the environmental management plan, are set out in the EIA report as one of the appendices.
Yeah.
And that's, I don't think that's one of the documents which is before you, ma'am, but it's one of the documents which
I'd have been asking for it.
We can certainly provide.
Right. Well, listen. It looks as if nothing very much would be gained, because you have had a dialogue with the local council, and you're in a position to update me at some point with exactly how matters have been resolved with them. So that can wait till the 22nd of August too. But I've at least made you aware that I'm going to need that, and maybe give you a bit of time on that. The next topic I wanted to touch on was the core documents list. And I did ask you for an initial list, and I realise that I didn't give you any time at all to deal with it. But your draft, it seems to me that quite a lot of the documents that you anticipated presenting are all going well, unlikely to be needed. But I wonder if perhaps you might want to think about what documents you would want to give me in order to ensure that my report is the way you want it to be. So there's a couple of ways of doing that. Either you think you give some thought to that now, or you wait for me to ask you.
One of the matters which we had hoped to discuss today, before matters have changed, were the topics that would be subject to further examination, and then those would be reflected in the list of core documents. But based on what we've just discussed about the three headings that you are of particular interest to you, we could augment this list with documents which support the position on these particular matters.
Well, why don't you give some thought to that then? Okay. And even, if the opportunity arises, work towards giving me a revised draft list on the 22nd of August.
Okay.
Okay? And I can, if necessary, use that as a menu. Okay. If you see what I mean?
Yes.
For things that I want, and let you know if there are things that I feel I don't require. I mean, I'm bearing in mind that you have a comprehensive statement of reasons, and there's much of that I think I won't need to go much further into, but it's more, if you like, the site-specific of this particular strip of land that I think I would wish to provide more information to ministers. Right, well, so if you would work towards giving me a revised core documents list on around the 22nd of August, okay, that's a good way forward, I think. Okay, right. Well, that's good. Then that's what we'll do. I'll not sis the case. We'll let it take over as a live case, and if you continue your dialogue with each other and see how far you get, and if you give me a joint report on the 22nd of August, and think about giving me a revised document list, and what you can call a core document is just supporting documents, on the 22nd in draft. And on that date, I'll review matters and issue further procedural directions. Okay. I'll do a note of today's meeting for everybody, so that everybody knows where they stand. We'll take it from there. Now, does anybody have any questions about what's been discussed from the objector's point of view? Is there anything you want to ask about? No? No? And does anybody have any other competent business? Anything else you want to raise? Well, if that's the case, then I think we'll close the pre-inquiry meeting. Good. Thank you very much indeed for your help. Thank you.
Thank you.